Mr. Elliott has filed a civil case. The respondent appears by, would you announce your appearance? I'm sorry, I don't think we're acquainted.
Lindsay Barach on behalf of all of the defendants.
Okay. All right. So you've accepted service, I presume, appeared, and prior to filing an answer, I think you filed a motion to dismiss. Is that correct?
Correct, Your Honor.
And we're here to argue that motion. Are you prepared, Mr. Elliott, to respond to the motion to dismiss?
Yes, I am.
Okay. Whenever you're ready, you may proceed. Counsel.
Good morning, Your Honor. This case arises out of plaintiff's allegations of medical malpractice related to treatment of an ankle injury that he contends occurred in March of 2021 while in custody. He previously filed suit in March of 2023 against these same defendants based on the same alleged injury. That case was dismissed by this court for failure to exhaust administrative remedies, and the Court of Appeals affirmed that dismissal. He's now refiled this action in September of 2025, asserting essentially the same claims based on the same facts. And this case should be dismissed for several independent reasons, but I'll first start with exhaustion. Kansas law requires inmates to exhaust administrative remedies before filing suit, including submission of specific personal injury claim form in accordance with the Department of Corrections procedure. In the prior case, this court dismissed plaintiff's claims for failure to exhaust administrative remedies, and the Court of Appeals affirmed that decision. In this petition, plaintiff still does not allege or demonstrate proper exhaustion. There's no proof that the required claim form was properly submitted to and received by the appropriate authority. So the exact same defect that led to the dismissal in the first case remains today. There's nothing new in the new petition that cures that defect. And so for that reason alone, dismissal is appropriate.
Let's take it one issue at a time, if you will.
Sure.
So, Mr. Elliott, what you're going to need to point to me is not a bunch of stuff for me to sift through, but an explanation, a document, and an exhibit that differentiates this case from the 2023 case. Otherwise, the issues are re judicata.
That does not apply because the saving statute 6513-18, requires you file the exact same thing. I cannot make the DOC answer my injury claim, which was filed, and they refused to give me a response. Now, after the courts dismissed it, they finally issued a response. It was first dismissed for filing petition too early because I didn't have all the paperwork.
Right.
Once I got all the paperwork, I've refiled it, and that is this case. They denied the claim here at the facility. A copy of that has been submitted with the petition.
Right, but there is a statutory requirement that within a specific period of time, you make a demand prior to filing a suit. That keeps the facts, the circumstances, all of that close in time to the injury for the state to consider taking it to the legislature and providing some compensation if they believe that there is liability, rather than several years later, you just being able to file a suit. So, and you know, these cases generally require an expert physician as well. That's the problem that I've run into with a lot of these civil suits. Instead of being 1501 cases, they become negligence cases, malpractice cases. It's been pretty common with regard to at least El Dorado Correctional Facility, which is the facility I deal with. And there, you know, as I explained to many inmates, there are plenty of plaintiffs' attorneys who, if they review a case and believe there's some validity to it, will take it on a contingency basis, even if you're an inmate. And they are the ones that procure experts to testify with regard to medical matters. It's very difficult, if not impossible, to prosecute, just setting aside the procedural error that's occurred, that apparently you can't cure because you can't produce a document that you gave statutory notice to the prison facility. But additionally, what is always, I think, compounds these cases is there's no offer of expert opinion or testimony that would support your claims.
Objection to that, Your Honor. I have new evidence from the doctor here at the facility who states I have a 30%, I have it right here on 2 different forms, and he states, per our visit on 4/14/26, I would put your disability at 30%. I will request outside OPR with Dr. Morrow, but it may not be approved. Dr. Morrow was the doctor that did the last surgery on my foot. This form is dated 4/13. On 4/14, when I actually saw the doctor, he wrote on this form, loss of left ankle strength and flexibility and pain disability is approximately 30%. So this is going to be mailed in after this hearing. I just received these within the last 2 weeks.
Well, what I really need you to supplement the record with is evidence that you complied with the statutory requirement to make a legal demand before filing a civil suit.
Your Honor, if you'll look at the injury claim form that was originally filed, it was notarized by staff, a Janelle Buchanan.
Which
It
is that?
Huh?
Which exhibit is that?
In this case, it is Exhibit GG, and it is the 3rd page, and this was submitted on February 28, 2023. Janelle Buchanan is the one who notarized it. She is the one that was supposed to take it to the warden and have it processed. I cannot tell staff what to do. I can't make them do their job.
It's not an inmate request, it's a demand letter. It's not an appeal and it's not an a grievance. It's a demand letter.
No, this here, the 3rd page, is the injury claim form.
Well, what I see is, I'm on G. I guess I need to find G.
Yeah, keep going. It's GG, Exhibit GG.
Oh, GH K M. Here's EE. Here's FF. Here's GG.
It should be the 3rd page of that attachment. Or that
3 of 3. 3 of 3.
Yeah, there's 3 pages to it. There's the first written page. It says attachment A at the top. Then the next page is the KDOC's response, although it's years later. And then the third page of that GG is the injury claim, which was notarized back on February 28th, 2023 by Janelle Buchanan.
Awfully procedural.
All right, so what I'm looking at is page 1 of 3. That's what you've marked it as. Original copy of 8, Exhibit GG, property damage, loss, or personal injury claim form. 200, you're claiming 200,000. This was 2/28 of 23. There's a backside for the warden and the secretary's response. And is it your position that this form was not provided? This is a new form from the 2023 case, even though this is dated in 2023.
It's the original form. They just answered it back on, they dated it July 8th of 2024. Because they never, the warden or the Secretary of Corrections never answered the injury claim form itself. But I got this.
Well, I don't, it doesn't trigger the statute whether they answer or not. It triggers, well, I mean, I guess it does, because if they give you the money you're asking for, it takes care of it. But it's the demand, the claim that, and a denial of the same that triggers it.
And they denied it, so that's why I've refiled it.
Okay, so, I'm not confident in that first case, the last case you had that was dismissed, that this form was in there. But what is your response, counsel, to the Exhibit GG, page 1 of 3?
Your Honor, to the extent Exhibit GG is an exhibit that was included in the original petition, I would argue that this court, as well as the Court of Appeals and their decision deciding that Mr. Elliott did not exhaust his administrative remedies, still applies to this case, and there's no difference.
Well, he's saying this is his exhaustion. This is his demand to the department, making a personal injury claim, asking for $200,000. It's form 01-118 capital D-001. Is this a form that the facility uses for property or personal injury that can be construed as a demand upon the state?
Your Honor, I
Yes.
can't find this exhibit in the materials that I have. I see where he references this exhibit in his second petition, but I don't see this exhibit.
I don't recall this exhibit in the first case, but I may be wrong. I would have to go look at the transcript, which I will do, to see what the argument was made, but I don't recall this particular form being part of the record in the 2023 case. But I will go double check that. And what I need to know is, does this satisfy the statute? Response was July 8th of 2024. I don't know that it's timely. I think that was part of the problem too, that it wasn't done timely, but I
Excuse
think
me,
the
Your
court
Honor.
previously found it wasn't done at all. And to me, there is a distinction between something that wasn't done versus it was done, but it is
You and the
late.
Court of Appeals originally had dismissed it because of filing too early. because I hadn't gotten a response.
Uh,
The
I-
petition.
I'll go look at it. I've gotta go refresh, my memory, but I wouldn't dismiss a case outright purely because I thought something was premature. It would have been because the prematureness of it would have been, you did not exhaust your administrative remedies and you did not make the demand letter specific to the statute that the legislature has provided that you must do before you as an inmate can make a claim, a liability claim against the state. So let me, I'm gonna have to pull that appeal. That's a separate file, and the transcript and the ruling, and see if this particular document was addressed. Now, you said this was part of the original appeal. Either it was part of the original appeal or it wasn't.
It was, Your Honor, but what you fail to keep in mind is I have to hand over my paperwork to the defendants to be mailed to you. Do you think they won't go through my paperwork and take out a document so that it's not there? They
Well,
will gladly do
if-
that. I just happen to have that happen with the joint committee claim. I just filed 2 claims with the joint committee claim. They state they got 1 claim. Now I'm having to resell or resubmit another claim to them, and it's being documented on the AWR form. The KDOC is notorious for going through our outgoing legal.
Okay, so again, you can't mix your theories. So either it was included in the first case when you filed it. It
was
wasn't included in the first case because they didn't provide it as part of the documents to you or ones that you were able to retain. I mean, either they were taken out before they were mailed and it didn't get to me because it didn't get mailed, or it was never there. What's your
I
theory?
put it with the documents when I handed it over to staff to be mailed.
Okay,
That's all I can say.
that still means then it wasn't part of the record in the first case.
It's irrelevant.
It's irrelevant.
Is it?
Who do you have sitting beside you?
All right.
There's no one beside me.
Who is talking?
There's another inmate in here listening and talking.
Okay, he cannot represent you.
He's
He
not
cannot
representing
speak
me.
to the court, and he needs to be quiet.
Yes, Your Honor.
And it's not irrelevant because it's only re judicata if it was presented to the court, ruled upon, and affirmed on appeal. If they weren't facts in the first case, then it's not re judicata. So I'm going to figure that out. It is very relevant. And we'll go from there. But I'm trying to get a direct answer from you, which is you made the demand. It was included in the packet. The packet that came to the court did not have all the materials that you submitted, or it wasn't submitted, or it was submitted. Those are your 3 choices. And I'm trying to figure out, you got to pick a position. It can't be all 3.
I know that at one time it was submitted with all the paperwork. I even remember, I believe, that you said you couldn't find it at one point, and I think I remailed that injury claim form. So, to my knowledge, without having my transcripts from that first hearings, it was sent. It was there. And
Well, I don't believe I ever saw this, but I have to go back and refresh my memory too. I have a lot of cases. So, I need to take a look at that issue, and I would ask counsel to take a look too. Amy, do you know how these exhibits were filed? How counsel would have access to GG?
Judge, if I recall, this was a case that came in, and I think the chief judge had indicated to the clerk not to file electronically everything because it was a replica of the previous case. I would have to double check that, but I believe that's how that came about. So I don't show that.
Well, I don't know how anybody would know that without comparing document for document.
Right, and
in
I
each
think that,
case.
I think that
So
was
these,
discussed,
these
but-
need to, these exhibits need to be filed so that council can have access to them.
And they're all the
I assume they were referred to in the petition, but these exhibits, I don't know who gave who instructions. Because I don't know for sure these are the exact same documents that were presented in the first case. You know, unless somebody, you know, unless the administrative judge wants to, the chief judge wants to take the, you know, take the case over, and that's his position, but I will have to, they have to be exhibits attached to a document. So they had to be exhibits attached to the petition and referenced in the petition. Otherwise, Mr. Elliott, you can't just send the court exhibits whenever you want and ask the court to exhibit, to admit the exhibits and to review the exhibits and to accept the exhibits. That's not how the process works. It is either part of the petition to establish your petition, or it's part of later trial evidence or hearing evidence that has to be admitted separately. It can't just be filed in the court file as evidence or exhibits whenever you send over documents. That's not how the process works.
I understand
So-
that, Your Honor, but both petitions refer to Exhibit GG. Both petitions.
But did you provide the exhibits with the petition?
Yes, I did.
Okay. Well, I will review that too. But we need to get, you need to be able to have the exhibits that he purports that support his petition to be able to consider it. And I apparently need to go page by page, exhibit by exhibit through the first case to see what is basically repetitive or redundant. And then we'll go from there. I will need at least 30 days to do that. And we'll figure out the, I can only authorize the clerk or direct the clerk to file your exhibits if they were part of the original pleading and they are referenced in the pleading as exhibits. Otherwise, they become separate exhibits for a separate hearing, and they have to be admitted in exhibit by exhibit through, you know, proper evidence presentation. So we'll see where we end up. I think Friday mornings are probably work best for the court when I do most all of my civil work on non-criminal docket week Fridays. Do Fridays work for you, Ms. Barash?
They do, Your Honor.
Okay, so you don't work 4/12s or 4/10s or 3/12s or 4/10s. Okay.
I
All
will be here whenever you schedule the hearing.
Okay, I think we will continue to do it by Zoom at this point. If there's no objection, but sometimes when we get to, you know, a significant amount of evidence, an introduction of evidence, so that we're all on the same page. Sometimes, especially with pro se folks, not to be necessarily critical. Some do a great job, but it's just attorneys usually confer about exhibits and documents before court, and pro se individuals, sometimes it's a little more difficult to have that level of communication. So there may be a point where I'll do something in person if I feel that it's necessary for the court to thoroughly review the documents for the hearing, but we're not at that phase yet. So I'm going to reset this as a Zoom hearing so that you have a chance to study the previous case if you need to. I need to, the current case, and be able to review all of the exhibits if you don't have access to them because they aren't electronically filed.
Your Honor,
Yes.
I send in copies of these two forms that the doctor signed showing I have a 30% disability in my foot. I will send you a copy of the original petition.
That goes to damages. That doesn't, that goes to potential damages. I don't think it's gonna help your petition, but let's just hold off on that. It may
Okay.
be part of your liability claim, but you would have to motion to amend. And they haven't filed an answer, so in all likelihood, if you get past the motion to dismiss, I probably would allow you to amend your petition to add those documents, but hang on to them.
Is it okay if I send you a reference to the exhibits?
There's no purpose in it. You can't send me anything.
first
You
petition.
file stuff with the clerk of the district court. I
Yeah.
don't take documents directly from individuals, witnesses, or attorneys. It's through the process of hearings
File it.
where they're filed publicly in the court file.
Okay.
And if you file too much stuff, nobody can see the forest for the trees, or if it's the other way around. It becomes, you're making your points, because it becomes so convoluted with things, that either aren't necessarily, beneficial, for your arguments, or, in some way they're not connected. So I understand what you're doing, what you want to add. What I'm saying is, what I'm asking you to do is hold on to those, because the first phase is this motion to dismiss, and they are entitled by law, before they answer, to file a motion to dismiss to be heard. If your petition clearly either doesn't state a claim, or it is prohibited because you've previously filed the same claim and it's been litigated. So anyway, let's just get this reset.